Is SEC trying to assault XRP holders? Is NASDAQ trying to help Ripple? Stay tuned till the end of the video to find out. But first, we are giving away 50 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribing to this channel to stay updated at all times. While there is SEC pulling the legs of Ripple with their new surprise attack, then their DigiVault, the NASDAQ-backed wallet that is accepting Ripple with open arms. Let's have a quick recap of what has happened over the last year. So, the SEC said in a civil case filed at the end of December that XRP should be classified as security since it was used to support the Ripple platform, which allows money transactions for merchants. The platform's leadership benefited from the XRP sales as well as from the operations of the platform. SEC says that these securities should have been registered with the Securities and Exchange Commission, and some financial information must be made available to the public under the SEC laws. The ultimate objective is to prevent fraud and protect the interests of investors in the financial markets. Ripple's response: the majority of the corporations who were targeted by the SEC in this way settled. That is not the case with Ripple, on the other hand. Rather than complying with the SEC requests, they have opted to battle the agency in court. Why? They assert that the SEC has been unfair in its application of the term security to virtual currency. If this is shown to be accurate, it will seriously weaken the authority of the panel, not to mention the legitimacy of their argument. The litigation is currently in the discovery process, which means that both sides are collecting information to support their respective allegations. Recent actions by the Securities and Exchange Commission have left many questioning whether or not past assumptions were correct. The regulator is using a successful strategy from another case to take aim at Ripple's most important arguments. According to the SEC, in September 2020, John M. Fife and 5 organizations controlled by him were hauled to court for selling $21 billion in penny stocks and making a profit of $61 billion without being registered as securities dealers with the SEC. The Fife defense used a similar argument to Ripple, claiming that the SEC had not provided them with fair notice and that the phrase dealer might be construed in a variety of ways. This argument was rejected by the court last month. Do you think it's a trick to delay the lawsuit by the SEC? Tell us in the comments. The Securities and Exchange Commission of the United States launched a surprise attack on Ripple Fair Notice Defense by filing a letter of supplemental authority to strike Ripple Fair Notice Defense in the Ripple case. Among the findings in the SEC versus Fife case, which was given on December 20th, was the court's decision to invalidate defendant John M. Fife Fair Notice Defense, which was granted by the Northern District of Illinois. The Securities and Exchange Commission filed a lawsuit against Fife and the 5 entities he controls in September 2020, accusing them of failing to register as a securities dealer in order to sell 21 billion newly issued penny stocks, resulting in an estimated profit of $61 million. The defendants' claim concerning how the Securities and Exchange Commission was obliged to alert them about the innovative meaning of the word dealer was rejected by the court. The SEC now asserts that the verdict offers extra power for eliminating Ripple's most important defense in the future. The letter states, indeed, Fife dismissed the defendant's fair notice argument at the motion to dismiss stage, despite the fact that he acknowledged the absence of binding authority in construing the word dealer, according to the letter. In the case of Ripple, there has been a legally enforceable authority interpreting the word investment contract since 1946. As a result, Fife grants Ripple greater discretion to strike his 4th affirmative defense. Naturally, Ripple's core argument of fair notice was being attacked by the regulator as a result of this rejection. In a similar vein, Ripple Fair Notice defense claims that the SEC failed to notify them of a possible violation of federal securities laws, and that the term investment contract is being misused by the regulator. Ripple claims that the SEC theory, that XRP is an investment contract, is wrong on the facts, the law, and the equities and ignores the economic reality that XRP is, and has long been, a digital asset with there has been no determination that XRP is a security by a foreign regulatory authority yet. In reality, the polar opposite is true. The US would be the unlucky anomaly in this scenario. The SEC is utilizing the most recent judgment of the Fife case to assert that the word investment contract has been constrained by legal constraints. In Ripple case, binding authority construing the term investment contract has existed since 1946. W.J. Howe County vs. United States, 328 U.S. 298-99. As a result, Fife grants Ripple greater discretion to strike his fourth affirmative defense. The phrases used in the instances, on the other hand, are different. The attorney Jeremy Hogan noted on Twitter that the conclusion of the Fife case marginally strengthens the SEC position in its motion to strike Ripple fair notice defense, which is why the SEC filed a motion to strike Ripple fair notice defense with the court. Oranges are the subject of one lawsuit, while orange juice is the subject of another. Both have orange in their titles, yet they are entirely different products because of where they are in the production process. However, despite the fact that the SEC is attempting to distance itself from the parallels between the two instances, Hogan asserts that Fife's was at a totally different stage of litigation and the standard is fundamentally different from the SEC versus Ripple case. The SEC filed a motion with the court to consider a recent decision that slightly supports the SEC position in its motion to strike Ripple fair notice defense. In this instance, the action occurred at a very different stage and the criteria used is entirely different from that in the SEC versus Ripple case. The timing of the letter of additional authorization is extremely odd, but DigiVault does not seem to be worried about the possible ramifications of the ongoing SEC versus Ripple litigation, which is now pending in the United States Supreme Court. When the Securities and Exchange Commission filed a lawsuit against Ripple Labs and CEOs Brad Garlinghouse and Chris Larson on December 22, 2020, cryptocurrency exchanges and digital currency asset managers such as Grayscale reacted with lightning speed, causing XRP to plummet in value. As a result of high demand for XRP, DigiVault decided to take the opposite approach and add it to its list of assets under custody. This decision was made in part due to the company's partnership with Asset Reality. Robert Cooper, DigiVault CEO said, "The value of digital assets along with the technology infrastructure that it supports can no longer be ignored, as reflected in the landmark increases in cryptocurrency participation we saw in 2021. But this increase in participation also put the spotlight on the risks of security breaches and hacks. Our business growth reflects this growing awareness by industry participants to be far more discerning in choosing accredited and regulated service providers. In the year ahead, we will maintain our focus on lifting the industry standards, driving greater awareness of ways to safely participate in the marketplace and by protecting our customers by continuing to expand the list of assets we are able to securely store for them." DigiVault actions could prove quite fruitful XRP holders. Do you think this will be the case? Tell us in the comments. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.